And I apologize, I was having a vote in another committee that is like a mile away. I mean, so I had to go do that vote, so I apologize for missing some of your testimony. I apologize for that. Now recognize the gentleman from Wisconsin, Mr. Tiffany, for his 5 minutes.
And Mr. Chairman, I was happy to pinch hit. Ms. Wilson-Palau, one requirement of the Cloud Act to enter these agreements is it has to be part of the Convention on Cybercrime. Is that correct? That's my understanding.
Yes, I believe so, although actually some of the other witnesses may be able to answer that better than I could. Yeah.
With that being the case, that convention also includes countries like Turkey and South Africa. While the concern is being most pointed towards the UK, and perhaps appropriately so, Turkey and South Africa aren't exactly exemplars of protecting people's civil rights. Shouldn't we be concerned about this extending beyond the UK?
Certainly. I mean, I think one of the most concerning aspects of this technical capability notice regime is, of course, the UK claims to be able to serve the notice actually entirely outside of the Cloud Act provision. So even if a country like Turkey or South Africa did or did not negotiate an agreement with an executive agreement under the Cloud Act, if they had a similar regime in place, as long as that's not blocked by the Cloud Act or some other U.S. law provision, they similarly could serve these types of notices on U.S. companies and may have much less respect for rights as you suggest.
Mr. Nojheim, do you have a comment in regards to what I just asked in the comments here?
So I think a lot could be done to ensure that the U.S. doesn't enter into agreements with countries that don't respect the rule of law. For example, the Cloud Act does not have a requirement that the U.S., that the country's laws require that there be even judicial authorization of surveillance. That seems like a very basic requirement, and yet it's not in the Cloud Act.
So it strikes me as I sit here and as we once again see that we have spies amongst us from China and the surveillance that's gone on, a spy balloon that flew over our country a few years ago. I mean, are we whistling past the graveyard of China freedoms that aren't they the greatest threat here?
I think that China poses a huge cybersecurity threat to the United States. And if countries like the UK can force our providers to disarm by removing encryption protection, then we're more vulnerable to that kind of surveillance and that kind of attack.
So you're saying that we would benefit by amending the Cloud Act to make sure that it's not abused by the UK, but perhaps other countries also. Is that what you're saying?
Yeah, think of the Cloud Act requirements in 3 buckets. There's the criteria that the country's laws and practices must meet. You could include a new one for protecting encryption. There are criteria that the agreement must include, things that the agreement must say. The agreement, right now, the statute says that the agreement has to be silent on encryption, basically. It should say it has to protect encryption. And then there's requirements about what the orders can and can't do. So amendments in those 3 buckets could protect encryption.
Mr. Salgado, were you with Google in 2018 when the Cloud Act was enacted into law?
I was, yes.
So in reading your testimony, I get the impression that you were a strong advocate for the Cloud Act at that point. Is that right?
That's true.
And now coming to us saying it needs to be changed. Didn't you sense in 2018 that there should be that we should be really concerned about that we were giving away too much with that Cloud Act in 2018? Did you have concerns at that time?
I did. There were some changes to the Cloud Act I would have liked to have seen, or some provisions I would have liked to have seen added. There wasn't anything quite on the horizon that we have with the UK now, but yes, there were some things that I thought we could do better with the Cloud Act. It was pretty good as it was passed, and it's been valuable. but it could use a tune-up.
So this is going to be a pointed question. It seems to me we have Google and Apple that are the subjects of this, in particular Apple, and we look at them in China and how they go about doing their business, where they have basically, in my terms, they've capitulated to the communist Chinese government. How do you reconcile that as someone who's a former executive with Google?
I'm not sure I totally understand the question. It may be better directed to somebody who's currently at Google who could explain that further.
I'm sorry that the gentleman's time has expired.